of filing and articles of incorporation, right? First, you need to know the corporation name. Okay. Kishore, every time whenever you are to file an incorporation document, you have to first reserve the name of the entity. So you have to choose a name. Okay. And this name needs to be distinguishable. So two businesses which are in the same nature of business cannot have the same name in the same state. Okay, which is why a database is given under every Secretary of State website wherein you can find for these names. Okay, so the name must be distinguishable on the records of the Department of State. You should do a preliminary search by name before submitting your document. The name must include corporation, company, incorporated, corp, inc, or co. Or if it is a professional association like law firm or accounting firm, architectural firm, then chartered professional association or PA is to be given. Okay. How you open a corporation name? You simply have to click in the hyperlink that they have given. Okay, so here they will let you look for the corporation. They will essentially, here you will type the name that you are going to give to the entity, and the search now will help you see if similar names are already adopted in the state. If not, then you can go ahead and reserve that name. Okay. Principle, now see, do not use or assume the name until it is approved, or assume that the name is approved until you have received the filing acknowledgement, right? So unless the articles of incorporation has been filed, it has been acknowledged, and you have been received the article of incorporation, you cannot use the name on any official business as of yet. Okay, only once the approval has been done by the state government can you then start to use the name. Okay, the principal place can basically be the street address of the corporation's principal office. Okay, and the mail address if it is different. Now this principal office, if there is no physical address, then this principal office is going to be basically the registered office, which is the address of the registered agent. Okay, as simple as that, right? Now, registered agent name and address, the individual or entity that will accept the service of process on behalf of the business entity is the registered agent. A business entity with an active Florida filing or registration may also serve as a registered agent, which means that they are situated in the state of Florida. An entity cannot serve as its own registered agent. However, an individual or principal associated may serve. So for the state of Florida, it cannot. Only for the state of Delaware and Colorado can the company itself serve as its own RA. But the state of Florida already explicitly bars that, right? The registered agent must have a physical street address in Florida and do not list their mailing address. Okay, only when they are either residing or they are operating a business will that address be termed as the street address. Okay, madam, have you drafted any AOI? I'm asking. There needs to be a written acceptance by the RA to show that they have accepted the appointment. So they also need to sign on your application, right? The signature confirms the agent is familiar with and accepts the obligations of subchapter 0505, which basically lists down the obligations of an RA in the state of Florida, right? Now, if a business entity is designated as the agent, an individual of the entity must sign to accept the obligations, right? So the RA can be an individual or an entity. If it is an entity, then any one person who is the authorized representative of the entity will sign the document. Okay. Now, corporate purpose, right? A professional association must enter a single specific purpose. For example, practice of law, accounting, etc. Right? Non-professional corporations are not required to list it. So unless you are incorporating a law firm, an accounting firm, and architectural firm, right, only then would you need to provide the purpose. Otherwise, if it is just a for-profit organization, you do not need to. Okay, because any which ways this comes as an optional part under subchapter 0202, right? Officer, director, again the names and addresses of theirs are optional. If individuals are listed, they are to be named as last name, first name, middle name, abbreviation. Okay. Leave the entity name field blank unless a different business entity is serving as an officer. Now, the Florida law states that the officer can be a person or a business entity, but if you are appointing a director, they cannot be a business entity, they only have to be an individual. Okay. Your effective date basically can be the date of filing, or you can also specify a later date. Okay, for example, if you are filing the incorporation today, you can specify in your articles of incorporation document that the effective date of this entity can be say 23rd of May 2023, so that the effective date of commencement of the business will be 23rd May 2023 and not 16th May 2023. Okay, so it can be the date of filing, or you can explicitly mention any later date, right? You have to enter the incorporator's signature, the correspondent's name and email. Now, certificate of status and certified copy are optional. You have to pay a filing fee for the state authority to give you a certificate of status and or a certified copy of the AOI. Okay, which means that you may choose, if your client wants, then you may choose for a certified copy of the AOI or a certificate of status. Okay, that basically lists what the status of the entity is, whether active, dormant, dissolved, etc. Right? So you can ask for these from the state authorities by filing a specific fee. Okay, and this will be only the requirement of your client. If they want it, only then will you ask for the same. If not, then it's completely okay. Right? And an annual report has to be sent. So this also is needed to be filed, but after the next year. Because on the day of filing your incorporation documents, there is no annual report that is existing of the entity, right? So every annual report needs to be filed a year later, okay? Which is a mandatory requirement that kind of makes or tells the authority whether your company is active or not. Now, if you are the incorporator, this will not be your responsibility. The RA will essentially be filing the annual report from the next year onwards, right?